Okay, so who can issue the search warrant? Um, Under Shattuck versus the city of Tampa. Okay, so as we were talking about there in the previous part, city of Tampa. So this is a criminal case, not a civil case. A person who is not involved in the activities of law enforcement may issue search warrants. And so, who does that include? Well, I have a list for you there. It's basically your judicial officers, clerk of the court, deputy clerks of the court, magistrates, complaint justices, justices of the peace, and judges. Now, um, you might look at this and say, what are all of these different people? So, every court has a clerk of the court. If you've ever received a speeding ticket or something like that, the clerk of the court is who you end up paying the ticket to, who you actually transact the final transaction with and give them the cash and they give you a receipt and some change. Unless it's one of those pesky court offices where they're like, bring exact change because we don't make change and all of that. But the clerk of the court is also the records keeper, if you will, for the court, in that they maintain the court's docket. They retain all of the transcripts of all of the trials, of all of the hearings and everything. If you file for divorce, you file it with the clerk of the court. Whenever we file a criminal case in court, it's filed with the clerk of the district court or the municipal court or whatever court it is that you're filing the case in. So then we have, let me skip over the magistrate for just a second to the complaint justice. So in some random hillbilly court systems in the United States, they're actually not going to be hillbilly, by the way. These are actually going to be probably in your more urban areas, like the city of New York or the city of Los Angeles or something like that. You'll find a complaint justice where they are basically just part of the assembly line of the judicial system, where they receive the complaint and issue warrant, an arrest warrant or something like that, or you bring them an affidavit and they sign it or don't sign it. They literally serve the purpose of signing court orders for law enforcement, essentially. So let's go back to the magistrate now. So the magistrate is an interesting fella. And a magistrate is very similar to the justice of the peace that you see there below the complaint justice. The difference being that in general, magistrates are usually appointed, but they may be elected, but they're usually appointed, where justices of the peace are usually elected rather than appointed. But they are limited in the scope of their ability to operate as a judge. In Kansas, magistrates are, well, they're, like I've said, they're similar to justices of the peace. But the thing is that you need to know is that a magistrate and a justice of the peace both, neither one of them is required to be law trained, which means that you don't have to be an attorney to then become a magistrate or a justice of the peace. So you find these folks that are magistrates, they're not law trained. They're trained by the court in criminal procedures, similar to the class that you're taking here, but they're not trained in the law and arguments and all of that. So a lot of times they're guided by the attorneys that appear before them. But they are the people's representatives within the court in that they are not law trained. But they are also deemed to be a neutral party. And then, of course, you have judges down there at the bottom, which are law trained. You do have to become an attorney before you can become a judge. However, with the exception of the clerk of the court, all of these people would be referred to as judge or your honor in court. So, okay, moving on. Okay, so let's talk about the grounds for issuing search warrants. Well, the Constitution tells us that they have to be issued based on oath or affirmation of probable cause, naming the particular place or person to be searched and seized. And this must exist at the time that the warrant is issued. You can't fix it later. So which is actually that next section there. Affidavits of probable cause must be complete. Whiteley versus Warden there tells us that the affidavit must be complete. Anything and everything we know about that case, good, bad, or immaterial, needs to be included in the warrant. So if you're working a murder and you got some friggin' idiot of a coroner that goes in there and disturbs the body and contaminates the crime scene, that information needs to be included in the warrant's affidavit. That way the judge that is, or the magistrate who is signing the warrant, knows that happened. And then under Arizona v. Evans, there at the bottom of this section, you'll see that affidavits may not be rehabilitated by supplemental witness testimony. That means if, oops, I screwed up and didn't include some information in the warrant affidavit, I can't then be sworn in by the judge and give supplemental testimony to get the warrant probable cause across the goal line. It's got to be in there or you got to pack your bags. You don't get two ways about it. It has to be there. The contents of the affidavit, it must indicate that a criminal offense has been or is being committed and what that offense is. You can certainly have more offenses than you list on the warrant, but you at least have to indicate what offense is occurring that this warrant is searching evidence for. General rule, I kind of subscribe to Whiteley v. Warden up there. If I've got a whole trainload of charges, I list the entire trainload on there. That way, the judge knows or the magistrate knows exactly what I'm looking at doing. Now, I may end up, after I conduct my search, adding additional charges or taking charges away based on lack of probable cause as it develops in the case, or additional charges because additional probable cause is stumbled upon. But I like to go ahead and put them all in there. Seizable evidence is at the particular place at a particular time. So on your warrant, you have to describe a particular place, and we'll talk about that under particularity. But you have to describe that particular place, and you have to demonstrate in the affidavit that the evidence that you want to seize is at that place at the time that you want to execute this warrant. And then you also have to demonstrate the method that law enforcement officers will use to identify the appropriate persons or premises. So basically, you have to, in your particularity requirement, you have to include it in there so particular that another officer reading your warrant couldn't hit the wrong house or seize the wrong person, if that makes some sense to you. So we'll stop there for this one and move on to part 3 in just a minute.